So far, we have seen how intellectual property rights can be developed, how they can be protected, sometimes by way of registration, and how they can be enforced before a court of law. Intellectual property rights makes sense for businesses because it gives them a strategic advantage in the market. Now let's look at how intellectual property rights interact with businesses and how businesses manage intellectual property rights. Now, how do you manage IP? Today's complexity of business requires any business, be it small or big, to factor in various considerations in the course of running their business. There are issues with regard to innovation, especially that arise out of technology and knowledge-centric businesses, which have to be kept alive. Not only is innovation important for businesses to survive, but they also need to constantly improve upon what they have already done to remain relevant in the market. So the cumulative nature of innovation puts stress on the business, not only to channel the investments that come into the business towards new products and new processes, but also to ensure that the investment that is being made into innovation is also protected. Intellectual property rights protection is too precious to be left to the lawyers. You will see that the best managed intellectual property rights in businesses come from an interdisciplinary approach that the company takes. It is just not something that the legal department of any company or any organization should be concerned with. In fact, you will find that strategic management of intellectual property rights would cut across the organization, and it would be relevant for everyone in the organization to know how to protect the IP. And this is especially important when there is fragmentation of IP. By fragmentation, we refer to different types of IP that would fall under different parts of the organization. For instance, R&D, or the products that come out of research and development from an organization, would be protected by the R&D department, and we could expect some kind of an intellectual property management cell or a patent cell in a knowledge-centric enterprise to be taking care of the patents. Whereas trademarks over the products could be protected by, say, the marketing department or the marketing division of that organization. If they have copyrights over their products, that could fall within the purview of a legal department. So in an enterprise that has different functions and that has products coming out covering different aspects of intellectual property rights, it is strategic for the organization to have a policy that cuts across the different types of IP and not to have a fragmented approach where certain IPs are held by certain parts of the organization. So, what organizations need to look at is to understand whether the intellectual property right is in sync with their go-to-market strategy, in the sense that the products that we are coming up with should be protected right from the time of development up until they hit the market and also beyond that. Now, who manages the company's IP? We had already mentioned that IP could be fragmented in an organization. So in some cases, especially the things that pertain to trademark, which is connected to marketing, it could be the sales and marketing. It could be the legal department, which looks at copyright and other related issues. It could be the finance and accounting department, especially if there is royalty coming out of the IP. It could be the research and development, R&D, and the technical department, which could be looking at technological innovation, especially when the company has products that can be protected by patents. It could be the human resources department in certain companies where the most valuable resource of the company are the people who work for it, and they generate the IP. So it could be the HR department that is looking at protecting IP. In tech companies, it could be, because they are largely IT companies, it could be the department that is in charge of developing new technologies. And in some cases, you could have companies constituting their own separate patents or an IPR department in itself. So you have a separate group which controls or which is in charge of all the IPRs that is generated in a company. An integrated management of IP would require different forms of IP, trademarks, patents, copyright, trade secrets, to be managed together. And the IP management has to be integrated with the overall business model design and the corporate strategy. Now, when we look at case studies later, you will find that most of the successful models of IP protection have revolved around the business model and the general corporate strategy itself. Now, IP, as we mentioned, because it falls into different buckets, they have to be managed together. So, trademarks pertain to marketing and branding, and the use of trademark could also extend to franchising. So, if you are using trademarks, then it is not just So, if you are using trademarks to protect your products, your concern is not just about branding and marketing your product, but also looking at how you can extend the trademark into your franchising agreements. So if you start a chain of restaurants and you are successful and you want to franchise that, then you would protect your products through a mark, so that when you have a franchisee working for you, apart from regulating the quality that the franchisee delivers, you could also have a licensing on the brand and a licensing on all the techniques that are transferred from you by way of a know-how agreement. That can be a contractual agreement, but again, you see that the strategy goes beyond just protecting them. Now you are thinking about how can you take your trademarks beyond your organization and how can they be franchised to others, and you can enforce them by stronger agreements and by protecting your brands through trademarks. So companies can take a call on whether they want to monetize their IP by sale, if it allows them to do that, or through by way of a license. In some cases, though a product is sold to the customer, the company may have a contract with the customer to say that though there is a sale, there is in effect a license that the person has purchased. Most of the software that we use are licensed software, though we may get an impression that we have bought the software for a price. So in many cases, a sale would extinguish all the rights that the right holder has, whereas licenses would ensure that the licensor has retained certain rights and only limited rights has been transferred to the user. So in deciding how a company or an enterprise will monetize its IP, it needs to decide whether it is going to use sale as a way to monetize its products and services, or whether it is going to use the licensing model. The company can also look at models for innovation. It could have a closed innovation model, wherein the innovation happens within the company, just between its employees, or it could also look at an open model for innovation, where certain aspects of the innovation which can be put out into the public, the company can look at crowdsourcing ideas from the open market. So integrated IP management requires intellectual property management to be tied to the firm's business strategy. Now the focus in doing this is how to make the business strategy inimitable so that others cannot copy it. The intellectual property position should be to ensure that whatever can be protected by way of an intellectual property right is protected, and further to ensure that the intellectual property right that has been created has an extended life. Now, the IP position of most companies is to extend the life of the IP. Now, this is important for us to understand because not all intellectual property rights have the same life. We had seen this. Patents have a 20-year life, designs have a lesser life, 15 years. Copyright has life of the author plus 60 years, whereas trademarks can have unlimited life. As long as they are extended, the trademark can be kept alive just by renewing and paying the fees. Trade secrets again is something that can be kept alive for a long period of time. As long as it doesn't fall into the public domain, the trade secret is regarded as a proprietary secret. So, the intellectual property position of any company which has different forms of IP rights with it would be to ensure that the IP protection is extended over a period of time. Now, if the protection is only with regard to one type of intellectual property right, say trademark, then the trademark itself can protect the company's brand, and as and when new products come in, there are going to be different trademarks filed over the products. So if you adopt the trademark strategy for protecting your products, your company's name would definitely be covered by a trademark. And every time you come with a new product, you're going to file trademarks which are unique, which cannot be copied, so that there is protection extended to every new product that comes out of your company. Similarly, if you're going to take a single point strategy in protecting all your products by way of patents, you would file patents as and when before you release a product. And you would also try to create a portfolio of patents around the product so that infringement cannot happen easily. So patent portfolio management is using a host of patents covering different types of approaches on your product so that you close all the ways for competitors to imitate or to copy you. Now, this can mean different things. One, it can mean you file more patents covering different aspects of the technology, different varieties or different variants of the covering different aspects of the technology, covering different improvements, additions and variants of the technology so that competitors don't enter into your field. It would also mean that as and when your patents are expiring, you file new patents so that the life of the technology is extended. So, in a product where constant innovation is possible, say every few years there is a new addition or an improvement made to that product, then it's possible to extend the life of the product by filing patents to cover those improvements and innovations that come over a period of time. So, in effect, the life of a product would be beyond the life of a patent, and we are talking about improvements that can be constantly made around a product. And in such a case, you will find that a portfolio of patents can cover a product even beyond the life of the initial patent. Say that if the initial patent expires in 20 years, but the product is something that is relevant and you can make technological additions which are valuable to the customers, then you could be filing patents as and when you make those improvements. So this is called patent portfolio management. Again, this is a single point strategy. In the earlier example, they were just trademarks using it. In the earlier example, they were just trademarks used to protect series of products. And in this case, you use only patents to protect a series of products. A publishing company may use only copyright to protect a series of products. So every time a new book comes, the company ensures that there is a copyrighted notice on the book and it is vigilant in protecting infringement. Now, as a part of integrated management of IP, a company could also adopt a business model to get an edge in the business. Now, the business model may be tied to IP protection. It could also be a non-IP business model in the sense that the company has an exclusivity in the field even without using IP. Now, integrated management also requires you to take decisions on timing, when to protect the IP. In some cases, an IP may not be ripe enough for a particular form of protection. For instance, there is a nice detailed write-up about a technology, but still the write-up in itself cannot manifest itself into a product or a process, which is a requirement for filing a patent. But nevertheless, the detailed write-up is valuable for people in the industry. And if you want to monetize that, or if you want to share it with an investor, there is a danger that the material that is disclosed can be copied and it can be commercialized without giving you due credit. So in such cases, it is possible for a person who owns the IP to have a confidential information protection by way of a non-disclosure agreement, an NDA, and disclose it to people who would be interested in investing into the technology and file a patent at a later stage. So the timing of the need to bring in IP protection and which type of IP protection can be critical with regard to how IP can be managed. Now, with regard to inimitability of business models, all businesses are interested in making the competition irrelevant, because that's the way in which you can have an edge over the competition. And if you make competition irrelevant, then you are exclusive in your market. And exclusivity can be conferred by different ways. Law does not promote exclusivity or monopolies. That is why we have a competition commission and we have competition laws which prevent one person from operating in the market. We want multiple players to be in the market so that the customers get the benefit. But businesses constantly come up with business models that are legitimate wherein they make the competition irrelevant. For instance, if you take software, majority of the computers run on Microsoft operating system. There are some which run on operating systems developed by Apple, and there are also others which run on open source systems. So now we find that just by having a business model, you could develop a strategic advantage wherein you make your competition irrelevant. Now, intellectual property gives you one of the tools to make the competition irrelevant, in the sense that if the subject matter of your product is protected by, say, patents or by trademarks or by copyright or by design, then you have an advantage which others don't have. For instance, no company can sell cola branded as Coca-Cola because it's protected by a trademark. No company can sell shoes with the brand Nike because that's protected by one company by way of a trademark. So intellectual property rights give you a strategic advantage in protecting your business in such a way that the competition cannot imitate you. The other way, if you don't use intellectual property, you could still protect your business model by a strategic business model management. For instance, there are various strategies. One that we have mentioned here is the blue ocean strategy. A blue ocean strategy is where you again make the competition irrelevant, but by non-IP means. So This would be a non-IP way of protecting intellectual property. So this would be a non-IP way of protecting businesses, whereas intellectual property would be what we call the use of IP to protect a business. Now, protecting businesses or having a strategic business advantage involves combining both law and management. Now, there are two kinds of IP which management scholars have identified, which is very different from the perspective of legal scholars. Management scholars identify IP and put them into two baskets. They are aware of the fact that there is fragmentation of IP. You have IP, you have different types of IP protecting different things. You have patents, designs, copyrights, geographical indications, trademarks. You have patents, designs, copyrights, trademarks, and a host of other rights. But they are also aware of the fact that for businesses, what is relevant is the fact that some of these rights are limited life IP, whereas others are unlimited life IP. So you have patents which have protection for 20 years, designs which can have protection for 15 years, copyright which can have protection for life of the author and plus 60 years after the death. Now, all these three rights have a limited time period within which they will remain relevant. And we had already mentioned, if you have a single point strategy, then you will be filing more patents one after the other, so that when your patents expire, you can have new patents covering up aspects of your technology that you have developed. But if your technology is static, say for instance, a pharmaceutical drug which can cure a disease, no matter how many innovations you come across around the innovation, that is the drug for treating a disease, they may not be substantial. They may be regarded as trivial, they may be regarded as incremental. So some countries, especially like India, there is a bar on protecting incremental innovations when it comes to medicines, because the medicine, the first time it is launched, it does its job of curing or treating the disease. So every time you come up with a slightly more efficient medicine, it is essentially, or the law presumes, it is essentially the same drug that does the job. So the law is not interested in granting monopoly or an exclusivity in cases where the drug does the same job. So, whereas in other technologies, such as fast-moving consumer goods, you could have product innovations that are substantial. Now, if you had seen the diaper industry, if you had seen baby diapers as a product, it over the period of time, it had seen host of innovations, and all those innovations were protected by separate intellectual property rights. So the first category is the category that we call limited life IP. And if you have to have a single point management strategy, then your approach will be to file more and more of the same right. So more patents protecting technology, more designs protecting all new designs that come out of your organization, more copyrights that protect the publishing, more copyrights that protect copyrightable works that come out of your organization. The other kind of IP that management scholars have identified are what they call the limited life, or what they call the unlimited life IP. In unlimited life IP, you have confidential information, what we also refer to as trade secrets, and you have trademarks. And the effort of management scholars has been to ensure how they can translate this limited life IP into this unlimited life IP. Now, the objective is to ensure that the exclusivity that IP enjoys continues for a longer period of time. So the objective in managing IP, when you manage IP together, there could be a possibility, and we will see the case studies where it is possible, to translate or to move the value from a limited life IP like patents, design and copyright into an unlimited life IP like trade secrets and trademarks. One of the companies that did this successfully was a company called Pilkington Glass. Now, Pilkington Glass came up with a patented technology for creating float glass. Now, this was many years ago. So you need to understand that float glass was a technology which replaced the existing technology that was plate glass. Now, this process involved pouring molten tin to create a surface on a glass sheet wherein the glass would float on the tin because it's lighter, and the resultant float glass was smooth and it required less grinding and sanding than the normal plate glass required. So the float glass technology in effect was more efficient, and it also reduced the existing process that was there, the plate glass technology. Now today the world entirely has moved towards float glass, and plate glass is used only in rare cases. What this did was it made it less expensive to produce glass, and the introduction of float glass was done by Pilkington, which is a British company. They had to convince quite a lot of users of their technology to say that there could be substantial savings, and they were slowly able to, over a period of time since 1960, they were able to move the entire industry from producing plate glass to float glass. Float glass was better, it was more efficient to make, and it was also cheaper. How Pilkington did this, despite being a small company, was by combining patents, which is a limited life IP, and trade secrets, which is an unlimited life IP. Now, they licensed their technology across the globe, mostly to Commonwealth countries, and they had licenses in such a way that any improvements that were made could be transferred back to Pilkington. Now, the rapid price reduction and acceptance of technology ensured that the technology spread quite quickly around the globe, whereas in United Kingdom, Pilkington was manufacturing the glass on its own. So it reached a point that the cost of manufacturing glass outside United Kingdom using Pilkington's technology was cheaper than for Pilkington to produce it within UK. So Pilkington even used this opportunity to import glass into Britain. What Pilkington achieved here was, initially when they came up with the technology, they protected it with patents, and with their collaborators who were using their technology, they had a trade secret agreement to ensure that the secrets, the know-how which were a part of the trade secret, were kept a secret. And they also had licensing terms wherein there was no further payment of royalty, but there was sharing of knowledge from both ends. This made Pilkington become a dominant player in the industry, and it also saw the world move away from float glass technology to plate glass technology. So float glass technology used to be in the market from the 1920s till the 1960s, and since 1960s the entire industry globally moved to the plate glass. Now this achievement is attributed largely to a combination of techniques in managing IP, and scholars have said this has come because Pilkington was able to translate their patents, which were limited life IP, into trade secrets which has unlimited protection. In another case study, which involves Dolby Laboratories, the company initially had patents, but then it converted the value towards trademarks. And as you know that most of us know Dolby as a trademark than for the patents that they own. And this is what Roy Dolby, the founder of the company, had to say. I have a general principle that I follow. I don't go into any area that I can't get a patent on. If you don't stick to that approach, you quickly find yourself manufacturing commodities. So a way in which Dolby has been able to get this recognition over a period of time was because initially they were protected by patents, but over a period of time they were able to move the value that was there for them in the patents to their trademarks. So every product that you buy which has Dolby on it, or every sound system that you experience with this mark, we attribute a technological advantage or a technological superiority just by looking at the brand. You may not know what is the technology behind it, but by looking at the brand, you attribute that it should be cutting edge. So this translation happened over a period of time, and that has been a successful translation of how you can translate the value from limited life IP, in this case patents, to unlimited life IP such as trademarks. So the IP strategy should be to integrate it with the business model, to ensure that different types are managed together so that it is not confined to legal, financial, HR or technical. Rather, there is, even if it is in these places, there should be a common understanding of who is doing what. And it should also be jurisdiction specific in the sense that you have to understand the laws that protect the IP. As I mentioned, there are certain incremental innovations pertaining to pharmaceutical substances which are not protected in India, but they could be protected in, say, the United States. So you should also understand the differences in protection offered by different countries before you can develop a comprehensive IP strategy.